In 1900, the average factory worker in America earned 20 cents an hour. That is not a typo, 20 cents. For a 10-hour shift, 6 days a week, with no overtime pay, no sick leave, and absolutely no guarantee that your employer would not cut your wages tomorrow morning without warning. And if you complained about any of it, you were fired on the spot and replaced by the next person waiting in line outside the factory gate. And here's the part that will seem almost impossible to believe. It was not until 1938, 162 years after the country declared that all men are created equal, that the United States passed a law saying employers had to pay their workers a minimum wage. The amount was 25 cents an hour. And even that was almost too radical for Congress to accept. This story does not start with a law. It starts with a machine. In the decades after the Civil War, America industrialized faster than any nation in history. Between 1865 and 1900, the country went from a largely agricultural economy to the world's largest industrial power. Railroads stretched across the continent. Steel mills lit up the skies over Pittsburgh and Birmingham. Textile mills hummed along the rivers of New England. Meatpacking plants in Chicago processed millions of animals a year. And all of that industry needed one thing above everything else: cheap labor. And labor was cheap because labor was everywhere. Millions of immigrants were arriving in American cities every decade, desperate for work and willing to take whatever they could get. Between 1880 and 1920, over 20 million people entered the United States from countries like Italy, Poland, Russia, Ireland, and China. Most arrived with nothing, spoke little or no English, and had no choice but to accept whatever work was available. Rural Americans were leaving farms and heading to the cities in search of factory wages. The result was a permanent surplus of workers competing for a limited number of jobs, which gave employers almost total control over wages, hours, and working conditions. The economics of it were brutally simple. If you would not work for 10 cents an hour, someone else would. If you would not work a 12-hour shift, there were 50 people outside the gate who would. Employers did not need to negotiate because they had no reason to. The country had no labor laws requiring a minimum wage, no laws limiting the number of hours a person could work, and no laws requiring overtime pay. There were no safety inspections, no workers' compensation, and no unemployment insurance. The government's official position was that the relationship between an employer and a worker was a private contract, and the state had no business interfering. To put those wages in perspective, in 1900, a loaf of bread cost about 5 cents. A dozen eggs cost about 14 cents. Rent for a tenement apartment in a city like New York or Chicago ran between $10 and $15 a month. A factory worker earning 20 cents an hour for a 60-hour week brought home $12 a week before any deductions. That left almost nothing after rent, food, and fuel. One missed week of work, one illness, one injury, and a family could be on the street. This philosophy, called laissez-faire economics, dominated American politics and jurisprudence for decades. It had deep roots in the founding philosophy of the country, in the writings of Adam Smith, and in the business interests of the men who funded political campaigns and controlled the nation's newspapers. The idea was straightforward. The market would regulate itself. If a factory paid wages that were too low, workers would leave and the factory would be forced to raise pay. If conditions were too dangerous, workers would refuse to show up. Supply and demand would sort everything out naturally without government interference. The problem with that theory was that it assumed workers had options. Most of them did not. In the textile mills of Massachusetts, entire families worked together, parents, teenagers, and sometimes children as young as 10, earning a combined income that barely covered rent and food. In the steel mills of Pittsburgh and Birmingham, men worked 12 hours a day, 7 days a week, in front of blast furnaces that could reach over 2,000 degrees. In the coal mines of Pennsylvania and West Virginia, workers were paid in company scrip, a private currency that could only be spent at the company store, where prices were set by the mine owner. The system was designed to ensure that miners spent their wages before they ever left company property. A miner could work 60 hours a week underground and still owe money to his employer at the end of the month. In the garment sweatshops of New York's Lower East Side, women hunched over sewing machines for 14 hours a day, earning pennies per finished piece. The sweatshop system allowed a tailor to subcontract work from a manufacturer, then hire others at a fraction of what he was paid, pocketing the difference. The result was layer upon layer of exploitation, with the worker at the bottom earning the least while producing the most. If you lost a finger in a machine, you received no compensation. If a fire broke out in the factory, you might find the doors locked from the outside because the owner did not want workers taking unauthorized breaks. You were, in every meaningful sense, disposable. Workers tried to fight back. The late 1800s saw an explosion of labor organizing across the country. The Knights of Labor, founded in 1869, grew to over 700,000 members by 1886, becoming the largest labor organization the country had ever seen. They organized across racial and gender lines, something almost unheard of at the time, and demanded an 8-hour workday, equal pay for equal work, and the abolition of child labor. The American Federation of Labor, led by cigar maker Samuel Gompers, took a different approach, organizing skilled workers into craft unions that bargained collectively for better wages and conditions, one trade at a time. Strikes became a regular feature of American industrial life. In 1877, a wave of railroad strikes swept across the country after several major railroads cut wages for the second time in a year. Workers in West Virginia, Maryland, Pennsylvania, and Illinois walked off the job. In Pittsburgh, strikers clashed with state militia, and over 40 city blocks of railroad property were destroyed. The Great Railroad Strike of 1877 was the first major nationwide labor action in American history, and it terrified both the business class and the government. The Homestead Strike of 1892 saw armed Pinkerton Guards, hired by management at Andrew Carnegie's steel mill in Pennsylvania, engage in an all-day armed standoff with striking workers along the Monongahela River. The Pullman Strike of 1894 shut down rail traffic across 27 states and territories when workers at the Pullman Palace Car Company walked out over wage cuts, and railroad workers across the country refused to handle trains that included Pullman cars. President Grover Cleveland sent in federal troops to break the strike, and the leader of the strike, Eugene Debs, was arrested and jailed. But the strikes rarely achieved lasting structural change. Employers hired replacement workers, called scabs, who were desperate enough to cross picket lines. Courts issued injunctions forcing strikers back to work on threat of arrest. The federal government repeatedly sided with business over labor, and the fundamental problem remained. There was no law that set a floor on wages. No matter how many unions organized or how many strikes were called, employers could always find someone willing to work for less. By the early 1900s, a growing number of reformers, journalists, and politicians began arguing that the market was not regulating itself and never would. The progressive movement pushed for government intervention on behalf of workers, consumers, and the poor. Journalists, known as muckrakers, exposed the conditions in factories, mines, and sweatshops to a public that was increasingly uncomfortable with what American capitalism actually looked like up close. These were not radicals. Many were middle-class writers working for mainstream publications, and the stories they told about what was happening inside the factories and tenements of industrial America shocked the conscience of a nation that believed in fair play. Ida Tarbell published her exposé of Standard Oil. Lincoln Steffens documented corruption in city governments. And across the country, settlement house workers like Jane Addams documented the living conditions of working families in exhaustive, unflinching detail. Massachusetts became the first state to pass a minimum wage law in 1912. The law was modest, applying only to women and children, and it relied on public pressure rather than legal enforcement. Oregon, Utah, and Washington followed within the next few years with stronger versions that carried penalties for non-compliance. These early laws were based on the theory that women and children were more vulnerable than men and needed special protection from exploitative employers. The amounts were small but meaningful. Washington's law, passed in 1913, set the minimum at $14.50 per week for a 48-hour work week, roughly 30 cents an hour. For a chambermaid or a factory seamstress earning half that amount, the law represented a significant increase in pay. But even these limited protections proved too much for the United States Supreme Court. In 1923, the court heard a case called Adkins v. Children's Hospital. At the center of the dispute was a 1918 law that Congress had passed to set minimum wages for women working in the District of Columbia. The law created a wage board with the power to determine what constituted a living wage and enforce that standard. A hospital and a female elevator operator challenged the law, arguing that it violated their constitutional rights. The question before the justices was fundamental. Did the government have the power to tell an employer how much to pay a worker? In a 5-3 decision, the court said no. Justice George Sutherland, writing for the majority, argued that wage laws violated the liberty of contract guaranteed by the Fifth Amendment. In the court's view, a woman had the constitutional right to agree to work for whatever wage an employer offered, even if that wage was below what she needed to survive. Setting a minimum wage interfered with that right and was therefore unconstitutional. The dissent from Chief Justice William Howard Taft was blistering. Taft, himself a former president, argued that Congress had every right to correct recognizable evils in the labor market. Justice Oliver Wendell Holmes wrote separately that the notion of liberty of contract was being used to prevent the most basic protections for workers. Holmes pointed out the absurdity of calling it a free contract when one party was starving and the other held all the power. But the majority held, and with one decision, the Supreme Court effectively shut down the minimum wage movement for the next 14 years. The consequences rippled across the country. State laws that had been passed in Massachusetts, Oregon, Washington, and nearly a dozen other states were struck down or abandoned. Politicians who had supported wage protections reversed course. Reformers who had spent years building momentum for labor legislation watched it evaporate overnight. The legal doctrine was clear and it was devastating. In the eyes of the Supreme Court, the right of a corporation to offer starvation wages was a constitutional liberty. The message from the highest court in the land could not have been clearer. The government had no right to tell employers what to pay their workers. If a woman in Washington was willing to work for 10 cents an hour because the alternative was not working at all, the Constitution protected that arrangement. But before anyone could mount another challenge, the economy collapsed. The stock market crash of 1929 set off the worst economic crisis in American history. By 1933, unemployment had reached 25%. 1 in 4 American workers had no job at all. Wages for those still employed plummeted. Factory workers who had been making 20 cents an hour saw their pay cut to 10 cents, then 5. In some industries, workers earned as little as 4 cents an hour during the worst months of the Depression. In the textile mills of the South, women were paid as little as 7.5 cents an hour for full shifts. In the sawmills of the Pacific Northwest, wages dropped below what they had been in the 1890s. Families that had been poor before the crash were now completely destitute. Breadlines stretched around city blocks in every major city. Shanty towns of makeshift shelters, called Hoovervilles, sprang up in vacant lots and public parks from New York to Los Angeles. Banks failed by the thousands. Savings vanished overnight. Families that had spent generations building small businesses and modest nest eggs watched everything disappear. The American dream of working hard and getting ahead became, for millions of people, a bitter joke. And the workers who still had jobs found themselves in an even weaker bargaining position than before the crash. Because for every person still working, there were 3 or 4 more standing in line, willing to take that job at any wage an employer cared to offer. The Depression did not just destroy livelihoods and savings. It destroyed the entire intellectual case for laissez-faire economics. The market had been left alone, and it had not regulated itself. It had collapsed spectacularly and taken the jobs, homes, and savings of tens of millions of Americans with it. The old argument that government should stay out of the economy was no longer convincing to a public that could see the results of that philosophy with their own eyes. The question was no longer whether the government should intervene in the labor market. The question was who would be bold enough to make it happen, and whether the Supreme Court, which had blocked every previous attempt, would let them. A political opening appeared that had not existed in the previous century of American history. If you're finding this valuable and want to see more deep dives into the hidden stories that shaped America, hit that subscribe button. We cover the history behind the systems and institutions you deal with every single day. Now let me tell you about the 2 women who walked through that opening and changed the country. Frances Perkins was not a politician. She was a social worker from Massachusetts with a master's degree from Columbia University and a career spent investigating factory conditions and lobbying for labor reform in New York State. In 1911, she had witnessed the Triangle Shirtwaist Factory tragedy in Manhattan, an event that devastated the garment district and became a turning point in American labor history. The factory fire trapped workers in an unsafe building, and 146 of them never made it out. Perkins later called it the day the New Deal was born. After the fire, Perkins threw herself into safety reform, eventually serving on the New York State Factory Investigating Commission and later as the head of the New York State Industrial Commission under Governor Franklin Roosevelt. When Roosevelt won the presidency in 1932, he asked Perkins to serve as his Secretary of Labor. She said yes, but only on one condition. She handed Roosevelt a list of priorities she intended to pursue as she took the job. The list included a federal minimum wage, maximum hour laws, unemployment insurance, workers' compensation, abolition of child labor, and a social insurance program for the elderly, what would eventually become Social Security. Roosevelt looked at the list and told her to go ahead. On February 28, 1933, Frances Perkins was sworn in as the first woman ever to hold a cabinet position in the United States government. She was 52 years old. She had spent the previous 20 years fighting for workers' rights from outside the government. Now she was on the inside, and she had the full backing of the president. But passing a federal minimum wage was going to be far harder than anyone expected. The first problem was the Supreme Court. The Adkins decision from 1923 was still the law of the land. Any federal minimum wage bill would be immediately challenged in court, and under Adkins it would almost certainly be struck down. Roosevelt knew this, and he spent much of his first term trying to navigate around the court. He even proposed a controversial plan to expand the number of justices, known as court packing, in an effort to shift the ideological balance. The second problem was Congress. Southern Democrats who controlled key committee chairmanships were deeply opposed to a federal minimum wage. The Southern economy depended on low-wage labor, particularly from black workers in agriculture and domestic service. A federal wage floor threatened to disrupt the entire economic structure of the South. Southern congressmen fought the minimum wage bill at every stage, demanding exemptions for agricultural and service workers, which effectively excluded the majority of black workers from the law's protections. The third problem came from an unexpected direction. Organized labor itself was divided. The American Federation of Labor, the nation's largest labor organization, initially opposed the minimum wage bill because it feared government-set wages would undermine collective bargaining. The AFL argued that unions, not the government, should be the ones negotiating wages. This put the Roosevelt administration in the bizarre position of fighting for workers' rights against both big business and the largest labor union in the country. Then something happened that nobody anticipated. In a small town in Washington state, a chambermaid decided to fight for $216.19. Elsie Parrish was a single mother who had gone to work at the Cascadian Hotel in Wenatchee, Washington in 1933. She cleaned rooms, swept floors, made beds, scrubbed bathrooms, and did every other task required of a hotel maid. She was paid 22 cents an hour, later raised to 25 cents for a 48-hour work week. That worked out to about $12 a week. Washington state had passed a minimum wage law for women back in 1913. That law set the minimum at $14.50 a week. Parrish knew she was being underpaid. She later said, "I took what they gave me because I needed the work so bad and I figured they would pay me right." They never did. When Parrish left the Cascadian Hotel in 1935, she and her husband sued for the back wages she was owed. The case went to the Washington Supreme Court, which ruled in her favor. The hotel company appealed to the United States Supreme Court, arguing that the state minimum wage law was unconstitutional under the Adkins precedent. On March 29, 1937, the Supreme Court ruled 5-4 in favor of Elsie Parrish. Justice Owen Roberts, who had previously sided with the conservative majority against labor protections, switched his vote. Chief Justice Charles Evans Hughes, writing for the majority, argued that the Constitution permitted states to restrict the freedom of contract when doing so protected the health, safety, and welfare of workers. The 1923 Adkins decision was overturned. Minimum wage laws were constitutional. A few days after the ruling, President Roosevelt made a remark that showed he understood exactly what Elsie Parrish had done. He told Congress that minimum wage protections should not be limited to women. He wanted a law that covered all workers. Frances Perkins went to work immediately. She organized a national committee of business leaders, labor officials, and industry representatives to build support for the legislation. Roosevelt lobbied Congress directly and made his case to the public through his fireside chats. In one broadcast, he warned Americans not to let any calamity-howling executive with an income of $1,000 a day tell them that a wage of $11 a week would have a disastrous effect on American industry. The fight in Congress was vicious. Southern Democrats demanded geographic wage differentials that would allow the South to pay lower wages than the North. The AFL and the CIO, locked in a bitter rivalry, fought each other over the bill's structure. In the confusion, shortly before the Christmas holiday of 1937, the House of Representatives took a surprise vote and sent the bill back to committee by a margin of 218 to 198. It was the first time a major administration bill had been defeated on the floor of the House during Roosevelt's presidency. Frances Perkins called it one of the most discouraging moments of her career. But she did not stop. Roosevelt redoubled his efforts in early 1938, lobbying individual congressmen and appealing to public opinion. Perkins organized support from women's organizations, consumer groups, and reform-minded business leaders. The revised bill dropped the most controversial provisions, including geographic wage differentials, and extended the timeline for reaching the target wage and hour standards. On June 25, 1938, President Roosevelt sat at his desk in the White House and signed 121 bills into law. Among them was the Fair Labor Standards Act. In its final form, the law established a federal minimum wage of 25 cents per hour, set to increase to 40 cents by 1945. It set a maximum work week of 44 hours, which would drop to 40 hours by 1940. It banned oppressive child labor in industries engaged in interstate commerce, and it set the general age of workforce entry at 16. The law was not perfect. It covered only about 1/5 of the American labor force. Agricultural workers, domestic servants, retail employees, and most service industry workers were excluded, exclusions that disproportionately affected women and black Americans. Southern congressmen had made sure of that, but for the roughly 11 million workers it did cover, the Fair Labor Standards Act meant something that had never existed before in American history. A legal guarantee that your employer could not pay you less than a certain amount, no matter how many people were waiting outside the gate for your job. The economic impact unfolded over years. Industries that had been paying below the new minimum were forced to raise wages or face penalties. Some employers predicted mass layoffs and economic ruin. The National Association of Manufacturers called the law a step in the direction of communism. Southern textile mill owners warned that their businesses would close overnight. Those predictions never materialized. Consumer spending among low-wage workers actually increased because people with more money in their pockets bought more goods, which helped the very businesses that had initially opposed the law. The 40-hour workweek, once considered a radical socialist idea that would cripple American industry, became the standard that still defines American employment to this day. Over the next few decades, the law was expanded to cover more workers. In 1961, Congress extended coverage to employees in retail and service enterprises, large construction firms, and gasoline stations. In 1966, farm workers and state hospital employees were added. Each expansion brought millions more Americans under the protection of the wage floor that Francis Perkins and Franklin Roosevelt had fought to establish. Frances Perkins served as Secretary of Labor until 1945, making her the longest-serving person in that position in American history. During her 12 years in office, she oversaw not just the Fair Labor Standards Act, but also the creation of Social Security, unemployment insurance, workers' compensation reform, and the abolition of child labor in interstate commerce. She never ran for elected office. She never sought public credit for the laws she helped create. When interviewers asked about her legacy, she deflected. She later said she came to Washington to work for God, FDR, and the millions of forgotten, plain, common working men and women. After leaving the cabinet, she taught at Cornell University until shortly before her passing in 1965 at the age of 85. Elsie Parrish collected her $216.19 in back pay. At the time of the Supreme Court decision, she was working at a laundry in Omak, Washington. She said she was happy with the results and intended to keep working. Nobody asked her to speak publicly about her case. She disappeared from the historical record almost entirely, and many of her descendants had no idea their grandmother had changed the course of American labor law. The story of the minimum wage is not a story about a number on a paycheck. It is a story about who gets to decide what a person's work is worth. For over a century, that decision belonged entirely to the employer. And the employer, backed by the courts and the federal government, decided that a worker's labor was worth whatever the market would bear, even if the market said it was worth 4 cents an hour. It took the worst economic collapse in American history, a Supreme Court reversal triggered by a chambermaid's lawsuit for 12 weeks of back pay, a president willing to fight his own party, and the first woman ever appointed to a presidential cabinet to change that equation. None of them could have done it alone. Elsie Parrish could not have won her case if the Depression had not discredited the court's laissez-faire philosophy. Roosevelt could not have passed the law without Frances Perkins designing and shepherding the legislation through a hostile Congress. And Perkins could not have built the political coalition without the moral authority she carried from 2 decades of witnessing what unregulated industry did to the people who powered it. The federal minimum wage today has been raised over 20 times since 1938. Whether it should be raised again is one of the most debated economic questions in the country. But the next time that debate comes up, remember what the country looked like before the floor existed at all. 5 cents an hour, 12-hour days, 7-day weeks, and a Supreme Court that said the Constitution protected your right to work for less than the cost of a loaf of bread. That was America without a minimum wage. It lasted for 162 years, and it only changed because people who had every reason to give up refused to stop fighting.